is people who provide a professional service, and it's not just designs and construction, but it is broader than that. In that first paragraph, look at a few of those items. Consultation, investigation, evaluation, planning, design, and supervision of construction. So it covers the gamut of things, and it talks about people hanging out a shingle, making a verbal claim they're an engineer, representing themselves as an engineer, and just people who hold themselves out as able to practice professional engineering. So it covers a lot of us on this call, as you saw from the poll questions. And we need to be conscious of when we say something or what people perceive us to be when we say that. And are they perceiving us as being a professional engineer when we are making comments or statements about certain things? Even if it's not our intent to do so, it's the perception of it. So Josh, if you, Matt, if you want to move ahead for me. So if you keep going in the state statutes, it says nobody can practice engineering, professional engineering, unless you're registered, number one. Number two, if you're exempt, and we'll look at those exemptions here in a bit. Or three, if you have a permit under a different part of the code. So a few of us are registered professional engineers. We have our stamp. We could operate on our own and be just fine. The second one, if you're exempt. So there is one of the exemptions. You may practice engineering within the scope of your exemption, and you are exempt from being registered as an engineer. So who are these people who are exempt? Go ahead, Matt. So there are a whole number of them. I think there might be 11 if I remember off the top of my head. But the second one is employees of the federal government when engaged within their state and practicing professional engineering for the government. And back in 1993 or thereabouts, exemption number 10 was added. Those that are employed by the county or the state in land and water conservation under chapters. And Matt's going to cover that a little bit deeper as we go. So we have any exemptions for a few people that are on the webinar. Go ahead, Matt. So as a federal person, we carry that exemption from state law into our policies. The National Engineering Manual supports the registration and the Wisconsin statutes and gives us the ability with our job approval system to do planning, design, and installation of conservation practices. So go ahead.
Okay, so on the DATCP or state side of things, the program that facilitates compliance with the Wisconsin Statute 443 that Scott mentioned is the Conservation Engineering Practitioner Certification Program. So since that's a mouthful, a lot of times we just refer to it as DATCP certification or DATCP engineering certification. But as Scott mentioned, Chapter 92 and ATCP 50 are the statute and rule that establishes the state side of the program. So in a previous slide, Scott mentioned that one of the exemptions allowing and performing engineering work was identified in 92.18. So here's that language. The department shall, by rule, establish a program of training and certification for persons who review plans for, conduct inspections of, or engage in activities under any of the following. And so it says this chapter, and that's 92, which is soil and water conservation and animal waste management. And also section 281.65, which is the financial assistance for non-point source water pollution abatement. So I didn't take all the language from 92.18.2, but basically this part of the rule allows DATCP to do the 4 things listed there. Identify persons required to obtain certification, establish the requirements of the certification, establish the different levels, and so that's the job class levels that we'll talk about later on, and identify persons to train. So part B of the language in subsection B talks about establishing the requirements of certification and includes the text at the bottom of the slide, which basically says, to the extent possible, the DATCP engineering certification will model the NRCS job approval. So here's the language from ATCP 50 that talks about conservation engineering practitioners, and then it goes on to list the activities a practitioner can perform within their level of certification. So basically, that is, having the appropriate certification level allows you to certify design plans and specifications as long as they're conservation engineering practices, and certify installation or construction according to that approved design or the applicable standards and specs, and also engage in planning review and other engineering functions related to the installation of engineered conservation practices. 50.46.2 identifies the conservation practices that can be certified. So these are the practices in ATCP 50 subchapter 8, which are the standards for cost shared practices. So these are the practices that are identified and that can be cost shared through our state soil and water resource management program, or SWARM program. The other ones that can be certified are the ones identified in the NRCS technical guide. So basically this equates to practices that show up on your DATCP certification form or your NRCS job approval authority form. So DATCP engineering certification, how it works. Basically, the rule states that there will be a state soil and water conservation engineer that oversees the field engineers, and that's me. And then I have the authority to delegate certification to the DATCP area engineering field staff that are located around the state. Then the field engineers can certify practitioners in the field, and that's the LCD staff and NRCS field staff. Those field engineers certify the applicants based on the four criteria listed there that are right out of ATCP 50, and that's the demonstrated knowledge, training, experience, and a record of appropriately seeking assistance. And that last one's important because it basically builds the relationship with your DATCP area engineer, that they know and have the confidence that if you get into a situation that you don't know the answer to, you'll ask the question. So then the next step is that the DATCP field engineer needs to sign the form, the practitioner needs to sign the form, and then that practitioner supervisor also needs to sign the form, agreeing to the levels that everyone has agreed upon. I'll turn it back over to Scott.
So Matt went through the rules that the state system operates under. Our federal system, we start with the general manual, section 210, which is engineering, and then the part 402, which establishes how we operate with licensed engineers with the job approval system. Our lead of that is the state conservation engineer, who is licensed in the state, and then he is authorized to approve all work within the state, and then may delegate that to others with the job approval system. If you look at the last sentence there, you'll see the familiar words of training, experience, demonstrated competence. What you don't see therein is assumed, as we are redelegating it out from our state engineer to the area engineers and out, is that trust factor Matt just talked about. seeking assistance and having that working relationship and working under the supervision of that delegating engineer. Next, Matt. Continuing in that section, for those of you who were with us a few weeks back for professional engineering ethics, you can see the general manual carries that concept through as well, talking about being ethical in our use of engineering and how we do that. Getting a little further down, looking at C, item C there, the risks that we take on and how do we do that? By looking at the degree of care that the engineer takes in any given circumstances, using current standards of practice and within the agency or in the profession, and then working within your area of expertise. With our programs as broad as we are, we get challenged in that, but we also have lots of resources we can call upon so that we're working under the direction and advice of others to help carry that portion out. So I wanted to bring up the words here. It talks about being sued, but what I'm really trying to get at is performance of work in the line of duty. When Jacob talks, you'll hear that a little bit more of, are we in the line of duty? Are we within scope of our approval systems and the things that are attached with it? Next one, Matt. So from our general manual, it carries down to our engineering manual, the National Engineering Manual, talking about the practice of engineering, referring back to the general manual, setting up the approval authority, talks about delegating, there's the trust. In the system, that's how we maintain compliance with the state law. It is a quality assurance program that keeps us in line with state law and doesn't get us booted out. Because remember, this is an exemption from the state. If we lose that exemption, we would be in a world of hurt to carry out the programs that we carry out. So next one, Matt. The thing to note on this slide is really the last point, that the younger you are in your career and having a system, it's good to have your levels looked at annually, because you're going to grow, you're going to gain experience, and we expect the levels to change rather rapidly in those early years. When you get in mid-career, it doesn't happen as often. You're typically doing the same practices over and over, sometimes a little larger scope. So it's not required to be reviewed as often. So go ahead, Matt.
Okay, so now I'll briefly discuss how the systems and job class levels work. Up until a few years ago, the DATCP certification and NRCS JAA forms were a joint system on one form. For a few reasons, the system needed to be separated, but they're still both very similar in how they work. So as you can see on this slide, the forms are essentially still set up the same. The major difference is that DATCP form only has engineering practices, whereas the NRCS form also includes, in addition to the engineering practices, it also has the ecological science practices. So things like cover crops and buffers, things like that. Excuse me. Sorry about that. For the most part, DATCP and the NRCS engineers work together to agree on levels and to try to make the forms match for each individual. However, since the forms are separate, there is the possibility that you could have different levels for one compared to the other. So that's why it's important that you know which system that you're working in. is it basically a federal project or a state project? So basically you need to consider whose professional engineer license are you working under? Are you practicing engineering on a federal project, in which case you need to be in the NRCS JAA system? Or are you working on a state project, in which case you need to check your levels in the DATCP certification form? Now, in some cases, maybe there's a project that has funding from both the federal and the state side. And in those cases, you need to check both of your forms to make sure that your levels are appropriate before approving the projects. So speaking of checking the levels, this is how both forms are set up. Based on the survey, it looks like most of you probably are familiar with this, so I'll just do a brief overview of it. But basically on the form, you identify the conservation practice that you're working on. And then you need to figure out which job class it is. So that's classes 1 through 5. And those are basically, 1 is less risky and class 5 is typically more risky. That's kind of how it's set up. And those are based on controlling factors. So that's the criteria that establishes the job class levels. And then finally, over on the right-hand side, these are the levels that you are assigned for planning, design, and construction. So you can have different approval levels for planning, for signing off on a design, and then at the end, signing off on construction. Now, I'll cover these a little more detail in some of the examples that we go through later. But once you determine that you have the proper levels, 50.4611 talks about how you approve the design or construction of a project. And basically that basically requires that you sign and date the plan. So here's the key reason for the job class levels I described on the last slide. Any person approving a design shall have job approval authority at the level required by the engineered practice. So this leads into the next slide and the remainder of our conversation, which is scope of certification. ATCP 50.4612 describes the scope of certification, but basically this means that no practitioner may certify any matter in a job class more complex than that for which the practitioner is authorized. So this means that you cannot approve practices for job classes higher than you have identified on your form. So in the event a practitioner exceeds the authority authorized for certifying conservation practices, the department shall review the matter and may take action under subsection 7 or 9. And 7 is reviewing certification ratings, and 9 is suspending or revoking certification. And I believe we'll be covering these in more detail as we go along here. All right, so in the next section here, we'll be talking about working in and outside the scope of employment, the legal liability aspects of it, and some examples. So with that, I will turn it over to Jacob.
Thanks, Matt. Thanks for the opportunity to be presenting today. When I was working through some of the material and looking at this, on the one hand, it can be viewed as a difficult situation when your industry or the area that you're working in has such specific certification requirements. But it also can be viewed as a positive, that there are very clear standards that everyone in your industry needs to meet in order to maintain certification. And so while I would admit it's a double-edged sword in that there are clear requirements that cannot be met, so long as you are meeting those requirements, as we're going to see here, you are likely to be found within the scope of your employment. Before we get to the specific examples we want to talk about, we want to just take a step back. And even for somebody like myself that works with a lot of local units of government and work through these types of issues, it's good to take a step back and just kind of analyze what the foundation is for this sort of concept. So the concept is respondeat superior, basically just kind of outlining that principal and agent or agency relationship. Throughout here, I'm going to cite some cases in case you're really interested in digging in on this. I'm assuming you're not, but it's good just to have the cases because a lot of this is based on common law. As we see here, this really dates back to 1866 here in the state of Wisconsin, as far as a clear line of cases dealing with when is that employee or agent not within their scope of employment. That second point I think is an important one to keep in mind, that the employer, so whether it's state government, county government, even the federal government, they are vicariously liable based on this principal-agent relationship, even if there's absolutely no wrongful acts on the part of the employer. So obviously, quite a bit of liability or potential liability on the part of an employer, but then a big responsibility for the employee, that you're essentially representing your employer. And obviously, when it's a governmental unit, the stakes are higher. The analysis or you're kind of put under the microscope, so to speak, on some of these projects. So a lot of responsibility for you. One of the main kind of factors that a court's going to look at with that principal agent or employer-employee relationship is this concept of control. So how much control does the employer have over the employee? And then based on that analysis, when an event occurs, was that employee acting within their scope? And if they are, then there's going to be a duty to defend on the part of the employer. So next slide, please. So like I said, this has been given an expansive review, and there's pretty clear standard set by both common law or the courts, but also here in Wisconsin state statute. So again, we're looking at a few maybe more ambiguous factors. Another one that we can talk about in the Olson case is the intent. And what is the employee's intent? Are they intending to carry out their responsibilities representing their employer? But thankfully, we do have a little more specific standard. So it's 895.46. That's simply the standard for when an individual representing or working on behalf of a governmental unit, are they acting within their scope of employment? So sometimes when you look at, hopefully you haven't been involved in litigation, but if you have, sometimes the plaintiff will simply state that the individual was acting within their official capacity. And kind of so, in that sense, possibly removing any sort of question as to whether or not you were acting within the scope of your employment. If you haven't been, there still will be kind of a secondary analysis. You'll be looking at the individual and looking at whether the acts were committed while carrying out duties as an officer employee. And then in that situation, if you haven't actually been named in your official capacity, then the court, or if it's a jury trial, will make a finding as to whether or not the defendant was acting within the scope of their employment. And then kind of that last part I think is important. If you're working for federal, state, county, there's going to be insurance coverage. And then in the event any sort of damages exceed the coverage liability on the part of the insurer, then that excess amount will be or should be covered by the employer, again, assuming you're working within the scope of your employment. Just again, because we're kind of talking big picture here, sometimes you'll hear these restatements of various areas of the law. So Wisconsin does follow the second restatement of agency, which again is a nice kind of tool to look at, and the courts definitely will. So as you see here in this Olson case, they actually cite to the restatement second of agency. So they are important tools. So just a couple factors to keep in mind. So under the restatement, the conduct of the servant or the employee is within the scope of employment if that is of the kind he's employed to perform. So we always want to make sure, if you're carrying out a task, is it within your job duties and responsibilities? Is it something that you were employed to do or perform? We're going to look at time and space. A very specific example is there's a series of cases relating to employees that they're traveling or commuting to work. Is that part of their employment? If it's not, and something occurs, then there may be a determination that it's outside of your scope of employment. For example, or as opposed to, for example, first responders that, or if let's say you work for the highway department or something of that nature, clearly traveling or commuting may be considered within the scope of your employment. For the folks on this meeting or call, the question is, if you're going out into the field, is that part of your job? Is it part of your duties, that part of field work, going from maybe your central office out into the field, is that within your scope of employment? I think typically in your situation, it would be considered part of your employment. And then obviously, conversely, we can look at what is the conduct that would not be considered within the scope of employment, again, under the second restatement of agency. If you're doing something that's just simply you're not authorized to do, if it's well outside of time. Some of these cases get very fact specific. Individuals going out to conferences, partaking in conference activities or meetings, but then something occurs, let's say in the evening when they're out doing some entertainment related thing. Is that involved or related to the scope of their employment or responsibility? So we're going to look very specifically at time, at space between when events occurred. So those are the sorts of factors we're going to look at under the restatement second of agency. We kind of already touched on this, but in Wisconsin, the common law, this standard has been interpreted broadly. So we're definitely looking at time and space. Some of the cases that come up often is Olson. Javier versus City of Milwaukee is a very specific case. Block versus Gomez. So in particular, that last one, where employee fully steps aside from conducting the employer's business to procure a predominantly personal benefit. In that case, the court looked at that and made it very clear that conduct falls outside of the employment. So some of this is very basic, right? Are you working within the scope of your employment by actually carrying out the duties and responsibilities you've been hired to perform, or are you doing something that's simply for a personal benefit? In those sorts of cases, courts are going to, potentially find that you're outside of the scope of employment. As I said, this has been interpreted very broadly. There's examples, even potentially criminal conduct that has still been considered within the scope of employment, but we always want to be careful, right? Because anytime you have a large body of law like you do here, there are going to be situations where courts are going to find that the conduct was outside the scope of employment, and therefore there's no liability to even necessarily provide a defense on the part of the employer. Next, please. Like I said, there are examples where courts and applying various factors are going to find that simply this is not within job responsibilities. This time may be a factor. As I noted, there are cases regarding commuting where there's just simply no way to conclude that employee was acting within the scope of employment. I kind of highlighted this one. Number one, it deals with counties, but also sometimes courts get it wrong, and I'm not necessarily saying this court got it wrong, but this one may be one where we could have considered it within scope. But I guess just wanted to highlight this case that there are situations where a court is going to find applying these various factors that for whatever reason an employee is not within the scope of their employment, and so we still have to be careful. So I want to kind of wrap up this section by specifically applying what we already talked about. I think both Scott and Matt have done a good job highlighting the pertinent sections. So I just wanted to spend a minute here to really be specific. So under 5046, we're looking at a job classification that's more complex. So again, as I open up my remarks, I think it's kind of a double-edged sword, but let's I guess view it as in the positive. Typically there's a lot of employees that I work with where it's really not clear what the job standards are or what the certification process is. So while this can be maybe a source of anxiety, I would encourage you to look at it as in a positive sense, that there's very clear expectations for what you are expected to know and perform, and then there's kind of a gradual increase of responsibility. I think that's a good thing. There's a very clear process under ATCP 50.46 where if there is a situation where the certification is questioned, there's going to be a review process. And then there's some discretion. I highlight the fact that it's may. DATCP may take action under sub 7 or sub 9. And then also under 40205, some really good language relating to, I know it's kind of under the header of ethics, but some really good language relating to your obligations to provide services within the scope of your training. A lot of emphasis on an area of competence. So again, we can view that as maybe a burdensome expectation, or we can view it as a positive. And I would just encourage you to note that there's a lot of good language in these statutes and codes that provide very clear standards which have to be met. So long as you're meeting those standards, and as we just discussed, most of the case law is going to, I think, lend a lot of support to the argument that even if it's a close call, in those situations, there's going to be an expectation or an understanding that unless it's really intentional behavior, if there's been consistent adherence to these certification standards, that most courts are going to find that the conduct was within the scope of employment. Not always, and there's always that risk, but in light of these very clear standards, if you're meeting the certification requirements, I think most courts are going to determine that you were acting within the scope of your employment. And then the next slide just kind of piggybacks off this. Again, it's a very clear process that DATCP has. There has to be a cause determination. Now, it can suspension or revocation of certification can take place without prior notice or hearing, but there still has to be a cause determination. And many of you are probably familiar with Chapter 227. So again, a procedural chapter that really highlights procedural requirements. So very clear process. There has to be a cause determination. So again, I think it could be cause for anxiety for some folks, but I think it's actually positive that there's going to be a clear process to deal with situations that you may find yourself in.
All right. Thank you, Jacob. So the next part, we're going to get into some examples, but I thought I'd take a quick pause here. Unless there's a question that's really pertinent to what we've covered so far, I'll probably keep moving just because we're going to be running up against time here maybe.
Yeah, Matt, I think you can keep going. We do have a couple questions, but I think you might touch on some of these things a little bit later in the presentation. So we'll check on them at the end.
Okay, sounds good. Thanks, Josh. Okay, so in this first example, we'll look at something simple, a grassed waterway. And you can see this grassed waterway, we're assuming it has a 500-acre watershed. So we start off by looking at the conservation practice, the number and name, and then we need to look at what the controlling factor is. And for a grass waterway, there's just one drainage area, and we know it's 500 acres. So we come into the job class section and figure out where we fall there. And because class 3 or 500 falls between a class 2 and a class 3, we have to go with a class 3 because it's higher than the 500. So in this case, the person that designed this had class 3 for design and construction approval, so we're okay in scope. Now let's take a look at that same example, but now our watershed is 650 acres. So same criteria here, but you can see now we're just over the class 3 criteria of 600 acres. So now that bumps this one up to a job class 4. And in this case, while the person had planning job class of 4, so they could sign off on the planning portion of it, but they could not approve the design or approve the construction because they only have class 3. So in this case, that would be considered out of scope. Another example, let's take a look at a 402 dam project. And in this case, we're just hypothetically saying that it failed. So these are just hypothetical situations. But if we start looking at the 402 dam practice on the form, we can see that it refers us to the 378 pond standard. And I know that might be hard to see on the screen, but that means we have to go to the 378 portion of our job approval form or the certification form. And one thing to note before we do that, on the cover sheet of both the job approval and certification, there's this criteria that says that all practices that we work on have to be low hazard. And specifically pertaining to a dam, you know, that's important because there can be different hazard classes. So we need to make sure that we're working on a low hazard structure. So now we come into this reference portion of the 378 pond standard. This is where the 402 referred us. And now you can see in pond, there's a lot more controlling factors than just the one drainage area that we had in grassed waterway. So the assumptions there, we're assuming it's low hazard. We've done the check on that and determined that it is. Drainage area is 300 acres. So that puts us at a class 3 for drainage area. The principal pipe spillway, the initial design is looking like it's going to be a 24-inch. So we see where that falls here. 24-inch is also a class 3. And the storage volume is determined to be 25 acre-feet. So we got to see where that falls on the form. That's also a class 3 since it allows up to 30. And then finally, the embankment effective height. We determined that our embankment is going to be 20 feet in effective height. So that puts us between a class 3 and a class 4. So it's a class 4 job class. And we come over and look at the approval levels. And here again, this person had planning for class 4, but they do not have design or construction. So if they signed off on the design or construction of this project, it's class 4 and they would be considered outside of scope. All right, Scott, I'll kick it over to you.
If you could back up to the slide you were just at, Matt, that would be helpful for me. So one of the things as Jake was mentioning, it's a positive and a negative. There are times you're out on projects in that initial stage and you're just not going to know some of these specifics at that point. You know, so it's just hard. It's not that anybody's out to get anybody, it's to get us working and trying to maintain the integrity of the systems, to keep the exemption from state law that we have and make our programs able to be implemented. Now, 1 foot or the 50 acres we had in the waterway example is one thing, you know, what's going to be affected and hurt by being over that level. Now, 1 foot of elevation here in the dam example might be a total different situation. So all of the levels of different factors are not all the same. So it's important to remember that. So we had one in scope, one out of scope, and another one out of scope here with the dam. Let's look at, we have criteria for those. So let's move forward and look at some other examples. So if someone asked you about advice of designing a house or a wall capability, truss design, you know, are we in or are we out of scope with something like that? Go ahead, Matt. Yeah, Matt. You know, it's obviously out of scope because it's not one of those practices. It's not something we have technical expertise in doing. But, you know, for people who've seen a lot of construction and whatever, we might be tempted to go there. But it's not within the scope of the systems we operate under. So next one. Here's another example. We have a wet detention basin under DNR code 1001. It looks very similar to a dam. It's got pipes and principles we're used to understanding. We understand the math, we understand the language, pipe flow, routing of storms, sedimentation. It's things in our wheelhouse, right? But it's not something in our certification systems and on our job approval or DATCP certification forms. So this is one of those that's going to fall, Matt, outside of scope as well. just because of the, the nature of our forms. Doesn't mean we don't have the knowledge, but it just doesn't fit the mold very well. So we're getting a little more into the gray of, okay, what do I do? Does it fit? Does it not? Let's look at one even more gray here and have some thoughts and discussion. So we have a stream crossing. It's where a stream is at. Maybe the culvert is failing and we're looking at putting in a new culvert. But that part is easy. We got that concept very well. But does it matter what is crossing the stream? You notice a car in the photo. So is that just a driveway to a house? Is it a small township road? Is it the end of a township road where it now becomes a driveway and an access road for a landowner? Is this a township or a more major township road? Is it a county highway? You can keep going up. It's still a stream crossing, right? So it fits in the system, but what types of risk do you as an individual and as our employers, what risk come along with that? So it's that technically or willing to seek advice that Matt mentioned very early on. These are the type of situations that we're thinking about when those words were written of, do we get involved? Do we offer advice? Or do we step away and say, no, that's not within our scope, and others, engineers, should be involved in that practice? So it's an interesting question, and there's not clear answers all the time, but it involves a conversation. So let's look at one here in a little bit of what could go wrong. So flip ahead, Matt. So here's a road crossing, a stream crossing that we just had. I would hate to drive up on this one and have my name attached to it and everything else is like, would not be good. So let's say that the stream crossing, all the criteria were met and it was within scope and we had the approval authority. Would our employers stand behind us and say, yes, you were in scope of employment? Or maybe it's outside of scope, maybe you're 4 or 5 different degrees over. You had class 1 and this is a class 6. Then would our employers stand behind us and as if, taking on our exposure that we presented to them? It's some interesting questions of what can happen and what to do about it. So what are some of the things that you need to think about before stepping out and offering advice, consultation, or design or construction of one of these projects? So if you can think about some of those answers, I'd like you to put those in the chat and just, what are those things that go through your mind? Should we get involved or should we not? So Matt, if you want to flip ahead, which is, I think, what I just described to people, to have a conversation of, okay, in these areas that aren't always purely black and white, how do we make decisions of getting involved, offering advice, or not? So again, if you type some things into the chat, that would be helpful so we can continue the conversation a little bit more. Matt, Jake, you want to add some things while people are considering that and typing?
Sure, Scott, this is Jake. I think that was a really good, I guess, summary of kind of the factors to consider here. Again, I work on kind of the administration side with counties and school districts. And I mean, I can tell you how I would look at this situation advising administration. And that is, you know, like you had said, you know, category 1 versus 6. I mean, I think these become very fact specific. If, you know, back to maybe Matt's example of, you know, based on the acreage, you know, 3 versus 4. I mean, those, you know, those would be the type of questions I would ask from the administration standpoint. You know, okay, we missed it by 1. You know, why was that the case? And if it's a situation where maybe there wasn't staff adequately certified, you know, that's certainly a situation we'd want to work with to ensure that doesn't happen again. But from the employee standpoint, does that mean you know, the employer is going to abandon that employee? Again, I would argue in those situations that's very unlikely to occur. Versus, you know, Scott, maybe your extreme example of like a 1 versus 6, and then you have a complete failure. And those are going to raise some pretty significant red flags as far as, you know, why did we not have the right, you know, the correctly certified employee working on this project? You know, it probably will expose a whole host of problems from the employer's standpoint as far as, you know, are we understaffed in this area? Are we not ensuring that our staff have the proper certifications? So I think, you know, frankly, you know, we can go through all kind of the legal theories and the legal analysis, but at the end of the day, a lot of this is just common sense. If there's an explanation for maybe why there was a technical failure as far as certification goes, I think most situations the employer is going to back up that employee. You know, one thing we talked about, you know, in preparing for the presentation was, you know, the practical side of this. It's not really in your employer's interest to abandon the employees. You know, I do litigation on behalf of public entities, and, you know, as a litigator, you never want to be in a situation where, you know, you're representing the entity, the county, school district, state, federal, whatever the unit of government is, and you've made a determination that this employee has acted outside the scope of employment. Well, they're still going to be part of that litigation. They're going to have to get their own defense counsel. You don't know kind of the skill level of that defense counsel. You now have the potential for cross claims, and it gets really, really messy, and that's not a good situation. And so, unless it's something very egregious, again, I would look at intent. You know, if there's some sort of criminal element, unless it's something really egregious, it's actually in your employer's interest to have a unified defense. And even if it was even in a gray area, I'm, you know, as somebody who works with local governments, I'm still going to err on the side of let's have a unified defense. We can work, you know, if it's a personnel issue, if it's an employee that's kind of has a tendency to go rogue, we can kind of deal with that on the personnel side. But as far as the actual liability and defending the unit of government, I'm going to 9 times out of 10 err on the side of having a unified defense and kind of working through maybe certification issues later down the road. Let's make sure we have a unified defense and try to get the best resolution possible. So again, common sense and you know, just looking at the facts, as Scott kind of mentioned, I think you're going to go a long way.
Yeah, there's lots of questions coming in on the chat as I'm watching. So Matt, if you want to hit the return here, you know, so how do we, and really the engineer being Matt Woodrow and Steve Becker, you know, decide whether we should be providing assistance in any a given project? You know, there's agency policies, there's what's in the tech guide, there's our forms that we're working at, there's programs, and the big one, you know, is risk and liability of what happens when something goes wrong? What exposure does the agency have? And sometimes it's decision makers are going to say, no, we're not going to get involved with that just because of it, or we're going to do it different than we normally would attack an issue. You know, our standard procedures might not be applicable in this particular case. So, Matt, you have anything you want to add?
No, I mean, that was well covered. I guess I would just echo, you know, like you said, the risk factor. If you do have questions or concerns about that, you know, by all means, talk with your supervisor, talk with your area engineering contact, and ultimately that, you know, they can run it past me or Steve or, you know, Scott to get opinions. You know, if you're not comfortable with it, it never hurts to ask questions. You know, that's part of that criteria that we talked about earlier, the, you know, the record of appropriately seeking assistance. And this would be an example where it's a good time to ask for help.
You know, I'm looking at the questions of, you know, somebody asked, in the name of technical assistance, can we help and provide advice? You know, we do have technical expertise that we possess. We should work within scope, and, you know, there's, you know, 10 feet over or, you know, 100 acre feet over, there's differences in scale to that. I understand that. And sometimes we don't know the drainage areas exactly as we're offering those things. And I understand that as well. So have the conversations, provide good documented technical assistance. So if something does come up in the future, you at least have the basis of how you made the decisions you made and what advice was offered.
Scott, there is one question there that I'd like to bring up, and it's from Tina. You know, so can we assist our county highway department in figuring out if a culvert is undersized? So maybe not getting all the way to the point of doing design work, but is there liability there if we're just providing some calculations or some kind of analysis for a partner agency?
I would, if it is to that effect, and that's what I was just trying to answer a little bit of, is it undersized? You've heard me say it before, there's always a bigger storm, so everything we design is always undersized in some aspect. Figuring out the capacity of a culvert and handing that on to a different department and agency would be totally appropriate. Telling them the return period that culvert can handle and the analysis we use to come up with it would be totally appropriate as well. Do we get involved in the design of the road, which would include the shoulders and safety and everything else, which is not in our expertise? I would not go there. That would not be a comfortable place for me and exposure for my employer.
Okay, well, we are just right at the end of our presentation here. I do want to thank our presenters and thank everybody for attending this, and thanks to Penny for running this. I think we need to let you get out to a couple minutes of break before the next session begins here. Oh, yep, and thank you, Matt, for putting up the CEU sheet here. And like I said before, if anybody is a PE that needs to have a certificate, put your email address in the chat now, or talk to Chris.
Thank you all for attending.
And there's a poll out there too, if people can complete that quickly.
While people are responding to that poll, one other thing that I do always like to bring up whenever we're talking about job approval is, and maybe I'll let you guys address this, is so say an employee does not have job approval for a project that they have in their area. What does that mean? Does that mean they can't work on it? Does that mean they can't touch it? What does that mean?
Yeah, I can answer that. Basically, you don't necessarily have to have the job approval level to work on a design. And working on designs that are above your capacity is a good way to learn. You just need to make sure that you're working with somebody that does have the right levels, somebody that's going to, do the calculations along with you or review your work to make sure that it's right. And ultimately, they're the ones that need to sign off on it. So it's fine to work on projects that you don't have the levels for. You just need to be doing it with somebody that will ultimately approve it for you.
Yeah, I think the statutory language would be under the direction and control of.
And this is Jake. I guess I would just add, I think the last few minutes of conversation are important to point out. Again, I work with a lot of county administrations, and we always want employees to contribute to projects and, even cross-department, collaboration on projects. I think, between whether it's, the highway department and other departments, on the environmental side, there's always going to be conversations, and that's a good thing. That's what we want. Frankly, working with administration on personnel issues, individuals that are constantly saying, well, it's not my responsibility, I can't touch that. Frankly, that can be a source of frustration if it's for purposes of just, not getting involved in a project. So, I think to Matt's point, just be careful on, that final certification, final review, overview. But overall, we want collaboration. We want, many times you folks are going to be the ones that are going to have a lot of expertise that's really beneficial to your employer. And again, if there's a good relationship there, the employer is going to back you up. If even in that situation where you maybe get a little ahead of your skis, if the intent, remember the intent, we talked about intent under these cases. If the intent is to assist and improve a project, again, 9 times out of 10, your employer is going to back you up if that worst case scenario happens. But I think that's starting to be a theme here. Just listening to the last few minutes.
All right. So with that, I think we're over time. So we probably got to let you know, I threw back up our contact information on there. So if you do have any further questions that we didn't get to, feel free to reach out to us and we can try to help you out.